Standard form of contract with example. Business under A and Company employs 4,500 staff. How A and Company employs 4,500 staff in its business? Does its representative draft the contract paper with each of the staff member? Or it has a standard form of contract for the staff of the similar work? A standard form of contract are contract that are drafted by A and Company and signed by the another party, that is staff, without any modification or change. That means individually A and Company will not draft the contract for 4,500 staff in its business because it does not have that much time. So it has the pre-printed contract, or it has the pre-printed paper which is drafted by it previously, and another party or the staff has to sign it. Let me give you another example. Movie ticket. Does the person in the counter draft the contract paper immediately when you ask for the ticket? Or he will give you the pre-printed contract, that means movie ticket, that is already drafted. What if you do not like the provision stated in the back of the ticket? Can you bargain and redraft the contract? Or can you make him or her edit certain provision? They are essentially take it or leave it contract with no room for negotiation. So you cannot make him or her to edit, to amend the provision stated in the ticket. Let me give you another example of air ticket. The terms and conditions are written in the back of the ticket. There is no option to amend certain provision of the ticket. It is pre-printed contract, that is take it or leave it. It does not have the bargaining power to the weaker party. You can see the format of the standard form of contract here. This is the example of one airlines company. So you cannot change the provision stated in the in this contract paper because you do not have the option to change it. You have only the option to take it or leave it. Let me give you another example. Walmart has the greatest number of employees, approximately 22 lakh. How they hired the company? Any guess? Yes, with contract. Do they separately draft the contract paper for every employee? No. Then how? They have a standard form of contract, that is pre-printed contract. With this example, let me start the meaning and definition of a standard form of contract. A standard form of contract are those contracts that are drafted by one party and signed by another party without any modification or change. Though a standard contract presents the advantage of pre-printed standard format, they are essentially take it or leave it contract with no room for negotiation. A standard form of contract are agreement that employs standardized non-negotiated provisions, usually in pre-printed form. These are sometimes referred to as boilerplate contract, contract of adhesion, and compulsory contract, where the person is bound to accept or take it or leave it, as there are no choices or there is no negotiation against the printed form. These contracts are criticized for not having the bargaining power of the weaker party and opening up wide opportunities for exploitation. This contract fulfills an important efficiency role in the mass distribution of goods and services. These contracts have the potential to reduce transaction cost by eliminating the need to negotiate the many details of the contract. However, these contracts also have the ability to trick or abuse consumer because of the unequal bargaining power between the parties. The standard form of contract is a contract which is drafted by one party and has to be signed by the other. Generally, if the organization or the company is bigger, or if they have to hire more people, then they draft the contract by themselves, whereas the other party has to either agree or leave it. The objective of introduction of the standard form of contract is to save time and money of the parties. But if the goods or services are of monopoly, then it can be harmful to the weaker party. So we have to take care of this provision that if goods or services are of monopoly, then it can harmful to the weaker party. If you see the electricity bill, then you can see the terms and condition. If you do not like the terms and condition, if you do not want to pay some amount, tax amount, VAT amount, then you cannot deny it because it is drafted by one of the party and you have to accept because there is the monopoly. That means you cannot argue and deny on the certain points and terms and condition. According to Black's Law Dictionary, a standard form of contract is pre-printed contract containing clauses used repeatedly by a business or within a particular industry with only slight addition or modification to meet the specific situation. Plane ticket, bus ticket, train ticket are the examples. The terms and conditions are written at the back of the bus ticket. The terms and conditions are applicable to all the participants who collected the ticket from the counter. Usually, this type of contract is made for convenience and to save time. It is not possible to conclude contract with everyone where the other contract partners are in large number. To write a contract with each and every person who takes a ticket is inconvenient. So the main aim of this standard form of contract is to save time and money of the parties. Now we will discuss the features of the standard form of contract. The features of the standard form of contract are as follows. No position to negotiate. In a standard form of contract, the drafter drafts the contract whereas the other party agrees with the terms and conditions. So the second party is not in a position to negotiate on the terms and conditions of the contract. The second feature is it might be unfair to the weaker party as the standard form of contract is drafted by one of the parties to of the contract. Sometimes it may be unfair to the weaker party, so the weaker party has to accept it. This is also defined as private legislation, where the giant company has the unique opportunity to exploit the weakness of an individual. Here, what we have to understand is, yes, of course, contract is the standard form of contract as the standard form of contract is also recognized as the contract, but standard form of contract is drafted by one party and it has to be agreed by the other parties. I use the word private legislation here. Here private legislation, simply the contract is private legislation because it is drafted by the party themselves. So it is called as the private legislation. If you remember the historical jurisprudence where Henry Mann, he has discussed about the stage of legal development. In the stage of the legal development, he has rightly mentioned that there are two types of society. One is static society and another one is the progressive society. In the progressive society, he told that or he declared that the movement of progressive societies occurs from the status to contract. That means from the status to contract is the one of the symbol of the progressive society according to Henry Mann. But here what I'm trying to tell you is the sometimes standard form of contract which is drafted by one party of the contract may create unfair to the weaker party because weaker party has to accept or leave it. So therefore he or she might be in injustice because as it is drafted by the other party. The another feature of the standard form of contract is, it is pre-printed contract. That means standard form of contract is pre-printed contract, which means such a contract is in already printed form and it has to be agreed by the weaker party by signing it. It is also called that these contracts are pre-drawn. So standard form of contract is a pre-drawn contract, which means the terms and conditions are pre-drawn, written by one of the party. There are fixed terms and condition. The terms and condition of the contract are prefixed by the drafter of the contract. Sometime the contract might be like to sign on the dotted line. The features of the standard form contract is that the drafter prints the contract and the other party has to sign on the dotted line of the contract paper. And freedom, there is no freedom to the party. Also there is no freedom to the party of the contract. Either he or she has to leave or agree to the terms. Therefore we can say that there is unequal bargaining power between the parties to the contract. Moreover, these contracts also have the ability to trick or abuse consumers because of unequal bargaining power between the parties. Therefore we can say standard form of contract is pre-printed contract or pre-drawn contract. There are fixed terms and condition that is pre-written, and sometimes that kind of contract might have the dotted line to be signed by the another party. There is no freedom to the party to amend the provision, and there is no position to negotiate. The party is not in the position to negotiate. Sometimes it might create unfair to the weaker party of the contract. There are the rules regarding the interpretation of standard form of contract, or before that we can say there are the rules of interpretation of contract in the National Civil Code 2017-2074. A contract in Nepal can be oral, written or implied. That means it can be or it may be implied by the conduct of the party, or the contract can be created by the conduct of the party. The law of Nepal is liberal towards the weaker party of the standard form of contract. So we can see why and how it is liberal to the weaker party of the standard form of contract. The National Civil Code 2017-2074 has mentioned about the interpretation of contract, which is as follow. Interpretation, first rule of interpretation is interpretation according to the common intention. The standard form of contract or contract should be interpreted according to the common intention of the parties. So it should not be interpreted as the judge wish or as one of the party wish. There must be the common intention of the parties of the contract. The second rule of interpretation of the contract is interpretation according to the meaning of general understanding. If the intention cannot be established, the intention of the party cannot be established, a contract should be interpreted according to the meaning of general understanding that a reasonable person of the same prudence as a party to the contract would give to it in normal circumstances. That means it should be interpreted according to the general understanding. But sometimes it is said that the legal language is not like plain language. The jargons, the word in the legal language are very difficult. But here in the rules of interpretation, you can understand that it should be interpreted according to the general understanding. And third rule of interpretation is if one party to a contract knows or is deemed to know a statement and conduct of the other party, the contract should be interpreted according to the intention of such a party. That means first one is interpretation according to the common intention. Second is if the common intention could not be identified, then it should be interpreted according to the meaning of general understanding. Then if general understanding could not be drawn, then the intention of a party is very, very important to understand. And the fourth point is interpretation of entire contract. That means the contract should not be interpreted taking one of the statement or one of the sentence, whole or entire contracts provision, the provision, the terms and condition expressed in the contract should be interpreted. That means the terms and expression used in a contract should be interpreted in the light of the entire contract or the context in which such terms and expression are used. And the fifth rule of interpretation is all terms used in the contract should be given effect. A contract should not be interpreted in a manner so that all terms used in a contract are given effect without separating some terms for others. That means whole contracts should be taken into the consideration, and common intention is very, very important. So you can relate this part with the subjective and objective theory of the contract. That means subjective theories do the internal interpretation. That means it sees the intent of the parties, usually of the intent that was made during the drafting of the contract, whereas objective theories do the literal interpretation of the contract paper. Usually this is mentioned or written or expressed in the contract. So you can say this part from the subjective and objective interpretation of the contract, for which you can refer to the page number 38 of the book also. So there I have detailed information. I have included the detailed information regarding the subjective and objective theory. So at last what we can do is, in the rules of interpretation there are 5 rules of interpretation. First one is the contract should be interpreted according to the common intention. Second point is interpretation according to the meaning of general understanding. So third rule is intention of the party is very, very important. And fourth point is interpretation of the entire contract. That means one part or one section should not be interpreted, or whole contract should be interpreted, and all terms used in the contract should be given effect. So these are the rules of interpretation. Now we are going to discuss standard form of contract should include, what the standard form of contract should include in its content. So the very first thing in the standard form of contract is, if the terms are written in the back side of the paper, then in the first page of the contract paper it should state PTO, please turn over, see in back, continued, or it should also give the symbol indicating back. So there is something back of the paper, so that symbol should be given in the standard form of contract. That means if you have the bus ticket or train ticket or plane ticket, then in that ticket it should indicate, or it should give some hints that there is something in the back of the ticket. So if the symbol is given, then it will be easier that you will see if there is written PTO, please turn over, or finger pointing, there is something back to the paper, then you can see. So that is also, or the standard form of contract should also include that. Second point is, generally the terms and conditions are written in a very small font. That means the word in the ticket or that standard form of contract are written in a very, very small word, a small font, so it is very difficult to read. So that is also very important aspect that we have to understand. Sometimes people do not bother to read it also, because there is no benefit of reading, because they cannot argue in the points that which they don't like, or they cannot edit that point also, therefore they do not bother to read that also. And if we see the example of the tickets also in the queue, if someone is there to take the ticket, then he or she cannot even talk. In such a situation, to negotiate would be far-fetched. That means it's no, it that the means the person, the buyer cannot talk to the person in the ticket counter. So how he or she can argue that I do not like this point number one, point number two? So there is no such thing, or no such ground, or no such environment to talk also, and there is no benefit of talking or arguing on the points also. There are different areas for the use of a standard form of contract. The very first one is ticket. Bus ticket, train ticket, plane tickets are the example of the standard form of contract. They have the pre-printed contract, and the customer has to pay money for a ticket and has to sign. For example, Motor Vehicle and Transport Management Act 2049, Section 105 states that there is prohibition on traveling without ticket. A passenger cannot travel in public motor vehicle without holding a ticket purchased by paying the fare specified in his or her destination of travel. Section 98 of the same act states the forms of passenger ticket of a public motor vehicle are as specified, and a person who sells a passenger ticket should affix the seal of the concerned transport service on the ticket. The important point to be noted here is that the ticket is not drafted by the passenger and the transport company. They have the prescribed ticket, means the standard form of clauses are already there, which makes it a standard form of contract. Second is employment contract. In big companies, there are many workers that I have already given you the example of, like Walmart and other company. So it is difficult to have a separate contract paper for each of them. For is they have one pre-printed contract. Each worker is made to sign this pre-printed contract. So we can find this standard form of contract in this big company, or the parties to the contract are more, the number of the parties are more, than this kind of standard form of contract are used. So now your turn. I have 5 questions. You have to give the answer of this 5 questions. And furthermore, you can see the book also. The very first question is, why is standard form of contract introduced? Second, state the drawbacks of the standard form of contract. Third, what are the features of the standard form of contract? Fourth, how the standard form of contract is interpreted. Fifth, where is the use of the standard form of contract? Hereby I finished my lecture on the topic standard form of contract. Thank you very much. Thank you.